Hello and a warm welcome to Federal Special Program Capital Beat. All eyes today were on Supreme Court as to what the top court would say on SIR. But people have got disappointed. People are not happy with the way Supreme Court today dragged its feet on special intensive revision of Bihar. Now, what has happened today? Supreme Court today refused to stop the Election Commission of India from publishing the draft electoral rolls for Bihar on August 1st, as per the schedule notified for the special intensive revision. Now, this bench comprising of Justice Surya and Justice Joymalya Bagchi did not hold a detailed hearing today, as Justice Kant had to attend an administrative meeting with the CJI in the afternoon. Now, assuring the petitioners that the matters will be heard at the earliest, Justice Kant asked the lawyers to submit the tentative times required for argument tomorrow. So now it seems that the hearing will be held tomorrow. Now, what happened in the court? Senior Advocate Gopal Shankar Narayanan, who represented the ADR, that is Association for Democratic Reforms, he urged the bench to stop the notification of the draft list, saying that it is going to inconvenience about 4.5 crores of voters. Now, once the draft is published, the persons excluded will have to take steps to file objections and to seek inclusions. That's what Mr. Shankar Narayanan said. And then to that, Mr. Rakesh Dwivedi, who represented the Election Commission, he said that it was only a draft list. Then Justice Kant, what did he say? He said that after all, a draft list, this is a draft list, and he said that the court can ultimately strike down the entire process if any illegality was found. Shankar Narayanan then requested Justice Kant to make an observation that the process will be subject to the outcome of the petitions. And then Justice Kant said that such an observation was not necessary as it was understood. So has the court really disappointed? And given the fact whatever has come out in on all the law websites and across the news platforms, that Supreme Justice Kant had a meeting in the afternoon. It was an administrative meeting for which he had to attend, and therefore the matter could not be heard. So why this urgency not shown by the Supreme Court when it comes to SIR, or for that matter, any matter related to the Constitution? That is something important because it reminds us of the case which was associated with the appointment of the chief election commissioners and the election commissioners. It's exactly the same playbook which it seems the Supreme Court is trying to follow. So we'll ask these questions today as to why the Supreme Court today was not in a hurry. Second question is, will the matter at all be listed tomorrow? Though it has been said by the bench that the matter will be put up tomorrow. They've asked for the tentative times allocated for the argument, or will the matter be delayed further, which is after 1st of August? These are very important questions, and everyone is glued to what is going to happen to the special intensive revision case. Joining me this evening is a very special panel of guests. We have with us Jagdeep Chokar, who's the founder of the Association for Democratic Reforms. Thank you so much, sir, for joining. We have Sanjay Hegde, a constitutional expert and senior Supreme Court lawyer. Thank you so much, Mr. Hegde, for joining. We have renowned election data scientist, Dr. Pyarelal Garg, this evening for us. Thank you so much, Dr. Garg, for joining. And I'll begin with Mr. Sanjay Hegde. Mr. Hegde, has the Supreme Court really disappointed, or we should give them the benefit of doubt that let's wait for tomorrow? Do we really have that kind of time when it comes to the special intensive revision in Bihar? Yes, sir.
Look, I have an active practice in the Supreme Court, so it never disappoints me, nor does it surprise me. Okay? These things happen. Today is a Monday where the Supreme Court normally has admission matters, a matter which requires more hearing. They've kept it for tomorrow. In the meanwhile, the law websites have also reported the kind of conversation while the matter was being adjourned. Basically, the judge told the Election Commission that, look, have a more inclusive approach. The judge also told them that, why don't you look at the EPICs as well as the Aadhaar card as a basis for inclusion in the electoral list. The Election Commission lawyer seemed to reiterate what the Election Commission had told the court in its affidavit which was filed recently. Let's see how the court proceeds to judgment. I assume that there will be a hearing tomorrow. How long that hearing will be and whether it will be effective, or whether tomorrow will be only a decision to say, okay, we shall earmark this much amount of time for both sides to be heard, and that we shall start the hearing on such and such a date, that I don't know. But I don't think people need to be overtly happy or overtly unhappy with what has happened today.
Okay, so let's forget the overt happiness. I'm coming to the overt sadness part of it, Mr. Hegde, and then I'll come to Mr. Chokar. Isn't it really disappointing? Because people can ask the Supreme Court that, this was an urgent matter. It involved the democracy. It involved, how the Constitution is being treated. And people are talking about the fact that Supreme Court, it seems, is taking the matter lightly. You have a point when you say that there were a few other matters. It was a Monday. Now it has been listed for tomorrow. But what is the guarantee that this delay tactics will not be adopted by the court tomorrow as well? Just like it has happened in the cases of election petitions in the past.
Well, there is no guarantee in the courts. If I was a lawyer who could give a guarantee, I would probably be a multi-millionaire. But that's not how things happen. I can assure your viewers that there will be a decision. There will be a decision in good time, and that the Supreme Court is not powerless to act against anything which is done arbitrarily. The Election Commission had set itself a deadline of the 2nd of August for publishing their draft list. But if the Supreme Court says, no, hold your hands, we will have a hearing, the Election Commission will be bound to listen to the Supreme Court.
No, but I asked you this question.
Just 1 minute. Even if the list is published, based on the current thinking of the Election Commission, if the Supreme Court were to say, no, this is wrong, redo the list, the Election Commission is bound by it.
But I was asking you the question that, when it comes to Election Commission, also in the past, we have seen that Supreme Court refrains from giving very strong directions to the Election Commission. Maybe, that Supreme Court is a constitutional authority, Election Commission is a constitutional authority, and both of them don't want to step into each other's territory. And they maintain those Lakshman Rekhas. So is that the reason why Supreme Court appears to be dragging its feet? Is there a slight hesitation somewhere in the approach of the Supreme Court when it comes to election?
I don't think it's a case of dragging its feet just yet. You must also remember that the bench has changed. Justice Surya has just come in and he's heading the bench. So he may very well decide that no, Monday on which he has to decide 60 other matters is not suited for it. I will take it at my speed. So I don't see evidence of dragging the feet. The other question is that what is this great hurry on the part of the Election Commission to set the list in stone? The Election Commission has come up with some draft figures based on the data that it currently has. Data can always be relooked at, can be redefined based on what the Supreme Court ultimately says.
So I'll come to Mr. Chokar now. You're a petitioner, Association for Democratic Reforms is one of the petitioners. What were your expectations from the court? And are you disappointed that the matter wasn't treated that urgently as everyone had expected?
Well, before I come to your question specifically, let me mention a couple of things which I think where I differ with Mr. Hegde and with you, that there will be a hearing tomorrow. There may be a hearing tomorrow. Okay. But Justice Surya did say that you give me the timelines, give it to the court master. I will look at it and fix a date at earliest convenient. I will put it on a non-miscellaneous day. Now, my understanding of that is that the petitioners, lawyers will give their times that they expect to take to put across their argument to the court master. And then the bench will look at those times and then decide a date. So my understanding is that there is not going to be a hearing tomorrow. It is just collecting of this information and then deciding.
No, but
And
then this is all the more a bigger delay. If you are saying and you're suspecting that the hearing will not take place tomorrow, yeah.
That's what I'm coming to. So this is my understanding, and I may be wrong. My understanding is based on what I saw happen. I am not in the court every day like Mr. Hegde, and therefore his experience is much more reliable than mine, but this is my understanding. The other, Neelu had said that the court has said that if there is an illegality which is found, we will not hesitate to stop the whole issue. And illegality has already occurred. Those people who were on the electoral rolls from 2nd of January 2003 to 23rd of June 2025 have been removed from the electoral roll without following the due process specified under law. So that illegality has occurred already. We don't have to wait for an illegality to occur. And then this is number two. The third issue that the bench seemed to say to the Election Commission and to the petitioners that the Election Commission has agreed to accept the Aadhaar card and the voter ID card. So, so what? What is the problem? And our lawyer said they have not. They have written several paragraphs in their affidavit on these three documents, Aadhaar card, the EPIC, and the ration card. They have given reasons why these three documents cannot be included and cannot be trusted. Now, despite that, when the bench says that the Election Commission has agreed to do this, I was surprised. And with due respect to the court, I think they had not been there for whatever reason. They were not able to read the Election Commission's affidavit properly and in detail enough. And you said that they again said, why don't you consider? This is what they had said on the 10th. They wrote it down. And in the hearing on the 10th, Justice Joymalya said that since the Election Commission is a constitutional body, we will not direct them to do so. We will only make a suggestion. So it was keeping.
But today also, Mr. Chopra, they gave.
Hang on. It was to maintain the dignity of a parallel constitutional body. The court said we will only suggest that you consider it. Now, courtesy demand that if one body maintains your dignity, then you maintain that dignity in a reciprocal way. Election Commission has not done that. Election Commission has practically, not legally, defied the Supreme Court's instructions. Now, that if as a result of that, the Supreme Court again says, why don't you consider it? I am surprised how many times will the Supreme Court make suggestions?
Right.
Then the last issue, there is a well-known adage that justice delayed is justice denied. In this case, to the 2.5 or 3 crores or whatever the number is, justice is being delayed.
So in your view, Mr. Chokar, this is just a delay tactics? Would you call it a delaying tactics by the Supreme Court when it comes to SIR?
I will not call it a delay tactic, but I would say the Supreme Court, with all due respect, has not been able to understand and appreciate the urgency and importance. There is a saying that some things are urgent and some things are important. This is something which is both.
Okay.
And the Supreme Court should realize the urgency and importance, and therefore it should have taken it up. We wanted to take it up much earlier than today. Today it was listed because the Election Commission lawyer said, list it after the draft electoral roll has been published. And the bench said, no, we will do it before. and they took it as close as possible, and they said 28th.
Right.
Today the 28th hearing effectively has become infructuous.
Absolutely. And now very little time is left. 1st of August, the electoral roll, the draft electoral roll has to publish. I'll come to Dr. Garg now. Dr. Garg, Mr. Choker has very pointedly said what he felt about the Supreme Court hearing. What is your analysis? And what would you really say to the approach of the Supreme Court? You have Justice Kant, who had some meeting in the afternoon. The hearing could not be held. They've again given some verbal directions regarding Aadhaar and the epic cards. Now, whether the election commission will follow that or not, nobody knows. It hasn't followed as of now. And also in the affidavit, they've said that they won't agree to making Aadhaar and epic cards as the acceptable documents. So, what would you really say? Is the Supreme Court, we come to the question which we are asking on the program, that is Supreme Court dragging its feet on the special intensive revision case? Yes, Dr. Garg.
First of all, with due regard to the panelists and their experience in law, at least to my mind, to put election commission and executive authority, though a constitutional authority, equivalent to Supreme Court, a wing of the different altogether, one of the organs of the state, three organs. I don't think that they are equal. Yeah, the Supreme Court is above the Election Commission in any manner. It is, of course, Election Commission is a constitutional authority, but Supreme Court is one of the organs of the state. One. Two, now the Supreme Court, in all its humility, all its everything, they said we will not pass an order. Now, if the Supreme Court is not ready to say that you implement Section 23 of the People's Representation of People's Act 1950. If this cannot be said, then what will the Supreme Court say? Will it go on requesting that please stick to the law, please act as per law? And this election commission straightway saying, no, we will not accept the Aadhaar card. And Section 23 says something else. Now, the Supreme Court is to implement the law. If the law is not being implemented, the Supreme Court is to directly execute to implement the law as it is in letter and spirit. It is not being implemented. So I cannot, in my whatever administrative experience I have, I don't think that these type of things. We do respect each other. We do respect the institutions. But at the same time, the rule of law has to prevail. If somebody is trying to misuse your leniency or the respect for the other institution, then you have to tell no, it has to be done. Maybe you
So
still
what
use the
happens, Dr.
good
Garg?
words.
Dr. Garg, if tomorrow also the hearing doesn't take place, then what happens from here on then?
No, to my mind, I agree with Mr. Choker. Because the Honorable Justice has said, give us your brief, how much time will you take? And that to tell your court, okay, you tell the court master, whatever it is. No, then they will say, okay, we will see how much time, can we spare this time or not? So many things are there, so many other important things can come. Who knows till tomorrow what happens? So many important things can come. So I don't think that it is that simple that it will be heard tomorrow, definitely, or it will not be heard. But at least one cannot say that it will be done. No, even hearing. I am not talking about what will happen during the hearing, even the hearing, because it is in limbo. It is not clear. One, two. To my mind, whatever I have seen in the courts as an executive officer going to the courts time and again in the government cases and all that, my experience is where the court sometimes goes on latitude, gives latitude. It means the time should lapse automatically. The things should become defunct, infructuous. I think the petitioner may become infructuous. Maybe when the electoral rolls are published, then they will say it is a draft now. Go on, okay, you go. You filed your objections. If you have the objection, the election commission will, we request the election commission to seriously see and decide them as per law. They may go on saying this thing. They may go on advising good words and all that. But I don't think that this is a
Right.
issue when you are trying to. My question is, I'm not a legal expert at all. I don't know law at all. I am a person of medicine. But one thing is there, when the constitution says that you are to revise the electoral rolls before each election, means the reference is the previous electoral rolls. 23 years back, electoral rolls are being revised. To my mind, it is putting the cart before the horse. Now, whatever elections have been done, it means the appointment of Ganesh Kumar is also wrong. If 10% voters, now in Bihar they have said, 65 lakhs they have already identified. 10% voters are fake. If 10% voters are fake, then this parliament is fake. The Lok Sabha election was fake. And Ganesh Kumar was one of the people, concerned persons when the election was conducted. When the law was passed in the previous Lok Sabha, when Mr. Ganesh Kumar has been appointed, his appointment becomes illegal because it was a house which was elected by the people who were not the electorate in a real sense. Who is at fault? Who is responsible? So this is a serious matter for our democracy. We may say anything. We may not say people come
Right.
and go. This is a historical time that we are losing. We are really playing into the words and all that. There should be no compromise on this. That look here, you are to act as per the Constitution, as per the Representative People's Act 1950, as per the registration of electors registration rule 1960, and as per the conduct of election 1961. You
Right.
cannot go beyond that. If you go beyond that,
Yes.
the court is here to
Right. Now I'll
act.
come to Mr. Hegde. Mr. Hegde, now Justice Kant also impressed upon the ECI that instead of en masse exclusion, there should be an en masse inclusion. Now uh, they are telling the election commission, but no directions as such. Why is Supreme Court giving this kind of an impression that okay, they seem to be on the right side, but at the same time they cannot take on the election commission despite the exposes which have happened on the ground, despite the glaring irregularities which have been caught in the process of the SIR? Why such a soft approach towards the election commission? Or is that the way Supreme Court really functions?
No, it is the way that the court functions with regard to any constitutional authority or even with regard to a government. There are presumptions that the court works on. There's a presumption of constitutionality with regard to any legislation. There's a presumption that constitutional authorities know their boundaries and will act accordingly. Whatever comes in the press is not yet evidence. This court may raise it up, the court may look at pleadings which raise it, and then say, what is your reply to these things? The court will pass a final order only after hearing both sides. So right now, it has not got the time for having a full hearing. It is only trying to assess how much time it would require to get to a hearing, a substantial hearing, for the purposes of the interim order. And in the meanwhile, it has been telling the election commission, look, why don't you take a different approach? See, it's not this kind of suggestion is not in court proceedings is not peculiar to these proceedings alone. Even when they see a husband and wife fighting, divorce cases, they make suggestions. They tell people, why don't you two lawyers sit together, see whether you can come to some kind of agreement? Can you mediate this out? It's only when both parties come and say that, okay, we have drawn our lines, this is where we have joined issue, and this is what we want you to decide, does the court go into those questions. The court also tries to get out as much as possible out through consensus before it goes into the confrontational issues.
So I'll come to Mr. Choker. Mr. Choker, now what is the hope left? You yourself said that the court may not hear the matter. It's not sure whether they will take up the matter. But if the case is not taken up tomorrow, then is there any hope left? Then, of course, the damage is done now. Then Supreme Court, and is it not exactly the playbook court is following, which we saw in the case of the appointment of chief election commissioners and election commissioners?
You see, I would not use expressions like a playbook or a toolkit because we are talking about the Supreme Court of India. And I would not say that there are any patterns. But the fact is that when we filed the petition on the 4th of July, it is 24 days, and we don't seem to have made any progress actually in real terms, which is difficult. And this is a case which has implications for the state of democracy in the country, because the Election Commission has said that they will do it in all states in due time. And instructions have been issued to all chief electoral officers, etc. So this is a test case or a pilot project. If it succeeds the way it is going, with 65 lakhs people have already been removed, and today or yesterday we were told that there are 1 lakh missing voters. Earlier, till about 5 days ago, there were no missing voters. Now they have all of a sudden appeared a new category called untraceable voters. Or in Hindi, it is a lapata matdata. This category was not there till 5 days ago. So we are faced with new things which seem to, and the issue of citizenship. The election commission in earlier days used to go from door to door enrolling people. Now it is expecting people to come to it and request to be granted the right to vote. Now, such things are very significant for the country. And that is why I thought the Supreme Court should have taken a kind of a faster view on this. And from the hearing today, I am not very hopeful that that faster view would be taken. And if that is going to happen, that this will be on a kind of a regular track or the slow track, I think the best thing that the Supreme Court can do is what Justice Bagchi suggested in the hearing on 10th of July. He had suggested to the Election Commission that why don't you de-link the special intensive electoral revision from the state assembly elections, meaning thereby that the state assembly elections that will happen in November or something should happen according to the electoral roll prepared in January 2005. And this exercise of the SIR can continue in due time, because trying to do it, conducting a review and correction and revision of the electoral roll is by itself, in and of itself, is a very good thing. The
Yes.
problem is it is being done in too much of a hurry, in which one suspects that the saying that hurry makes waste or something like that might come true. And in this speed, we may make mistakes which are very serious, which may have grave outcomes in future. So we need to slow it down and de-link from the state assembly election. This can go on, and state assembly election can go on with the January 25 vote electoral roll, and there'll be no crisis at that time. So I think
Absolutely.
that is what Supreme Court should not only suggest to the Election Commission. I think it is appropriate that the Supreme Court directs the Election Commission to do that.
Yes, I was in fact just about to say that are we only expecting suggestions from the Supreme Court or some directions as well? Dr. Garg, what will you really say towards the end? The way it has begun today, that was the first day. First day is actually not very. It doesn't look like with too much of hope. What would you really say towards the end?
Secondly, I agree with Mr. Chokar entirely. The only alternative at this point of time, when the whole of the Supreme Court is so busy maybe tomorrow again they have some more important work and all that. And the law provides, the election law, the Representative People's Act provides it, that if you are, even the election rule, the registration of electors rules 1960, that if you are unable to revise the electoral rolls, you have to stick to the previous electoral roll. Here they have already revised. So that is the only solution and easy solution. Okay, we will think on, we will discuss, we will dilate upon, we will do brainstorming on the SIR. But let it not be linked with the election of Bihar or even Bengal coming till the issues are settled, the whole dust is settled. You go on with the existing things. That is the best way. As a trade union leader, we have been doing okay. For the timing, we do this, and we will go on fighting later on. So many times it is a time now that the Supreme Court, good sense prevails on all the sides contesting, that let us conduct the election in a calm and quiet manner without any, I will say, heart burning in any side. And it is a legalistic matter. If we have been doing this election from, say, 1/1/2003, what is going to happen is not going to fall if Bihar elections are conducted like that. So that is to my mind, that is the best way. But I have many, you can say, doubts that this will happen, because the SIR now is not being done to clean the electoral rolls. If had it been the idea, then it would have been done in a systematic manner, not in a hurry and all that. So when your idea behind is something else, you will not agree. You may use good words, you may do anything, but you will not do. So to my mind, this will not happen. But this is the only alternative for the country now. Even if the discussion goes on for SIR, the Bihar election have to be dealing, because this matter cannot, in a hurry, this matter cannot be decided in a hurry.
Absolutely.
It should be decided coolly, not with the high tempers and all that. So, and the way the revision has been done, so-called SIR, everybody knows it is not SIR, it is intensive removal. It is a special intensive removal of the electorate rather than of a revision. And this is what I will say.
All right, so let's wait and watch what happens tomorrow, and let's hope for the best as far as the SIR case is concerned. We'll have to end it here. Thank you so much, Mr. Hegde, Jagdeep Chokharji, Dr. Garg. Thank you very much for joining. Thank you.
So nice.